When we have to speak about dissolution of marriage by wife, is it possible? We have got something called talaq-e-tafweez, which is called delegated divorce. That is, at the time of the marriage itself, if the husband and the wife have come to an understanding that, or if there is a marriage agreement that, if a particular event happens or does not happen, or if a particular condition is fulfilled or is not fulfilled, the wife will have the right of dissolving the marriage. Like, say, for example, when the husband says that you are my first wife and I will not get married again, and in case there is a marriage agreement that if he gets married for the second time, the wife can utter divorce or utter talaq. The wife can do so only when the condition is fulfilled. That is, only if the husband gets married for the second time, she can utter talaq, which is called talaq-e-tafweez or the delegated divorce. What do we mean by delegated divorce? That is, the husband will delegate his, when I say delegate, I mean to say he will transfer his absolute right of divorcing his wife to his own wife on the happening or not happening of a particular condition, and the wife can exercise this right only on as agreed and nothing and as agreed only, and if the condition happens or does not happen, that is depending on the happening or not happening, her rights are restricted. Let's move on to another kind of extrajudicial divorce, that is by mutual consent. Under this, two broad categories are Khula and Mubarat. In the case of extrajudicial divorce by mutual consent, both the parties are not interested in continuing the marriage anymore. Both of them wants to both of them want to break the marriage, and they can do so either by resorting to Khula or Mubarat. In the case of Khula, it operates this way. When both the husband and wife are not interested in continuing the marriage, the wife will take the initiative of making an offer of dissolution of marriage to the husband, and she says whatever the dower, that is, in case the dower is unpaid, she can always forfeit her claim to the dower, and she can always say that I will not claim the dower, and that forms a consideration my for me to break the marriage. And if the husband accepts, fine, or he can also demand for more consideration. This is called khula. In the case of Mubarat, that is Mubarat, both of us are not interested in continuing the marriage anymore. Both of them approach each other and say, let's call it quits, let's dissolve the marriage. And in the case of Mubarat, there is no transfer of consideration whatsoever between the two parties. There is a mutual understanding to dissolve the marriage. This is called Mubarat. All this while we were speaking about extrajudicial divorce. Now, let's move on to the judicial divorce under Muslim law. Till 1939, a Muslim wife never had the right of dissolving the marriage at all. But for the first time in 1939, Dissolution of Muslim Marriage Act was brought in, that is a British legislation, and for the first time 9 grounds were given to a Muslim wife to break the marriage. Section 2 of the Act enumerates 9 grounds under which a Muslim wife can obtain a decree for the dissolution of her marriage by knocking at the doors of judiciary, because of which we call it as a judicial divorce, or now that under this particular category the judiciary will intervene and proceedings will happen before the judiciary. That is the reason it is called a judicial divorce. So under Muslim law, when I say judicial divorce, I mean to say it is by the judiciary, by intervention of the judiciary under the Dissolution of Muslim Marriage Act 1939. For the first time, a Muslim woman was given the right of dissolving the marriage under the following 9 grounds. The first one, if the whereabouts of the husband are not known for a period of 4 years continuously by his kith and kin, by his family members, by his friends, that is, if nobody has seen him, nobody has heard him, nobody has heard about him for a continuous period of 4 years, the wife can go to the court of law and make an application saying that the whereabouts of the husband are not known, because of which she can she can ask the court to dissolve the marriage. Based on the evidences produced, the court can dissolve the marriage, but there is a condition here. The decree of the court will become operative only after 6 months from the date of decree, and if the husband comes back within 6 months, the decree of the court will not have any effect and the marriage should continue, or the marriage will continue. And the second ground is failure to maintain. If the husband neglects or has failed to maintain his wife for a continuous period of 2 years, a married Muslim woman can obtain a decree for divorce by the court saying that the husband has not maintained her. Sorry. What is maintenance? Maintenance is nothing but food, shelter, and clothing. And if the wife is studying, he has to provide her even the educational expenses to her, or in case she is compelled to stay separate because of the default of the husband to pay the dower, she has every right for separate residence and he has to pay for her. So under these circumstances, if the husband has not maintained her for a continuous period of 2 years, the option of filing an application for dissolution of marriage is available to the wife. The next ground is imprisonment of the husband for 7 years or more. If the husband is imprisoned, or if the court has imprisoned him for a period of 7 years, the Muslim wife can approach the court of law asking the court of law for dissolution of marriage, but then she has to allow the husband to exhaust all available remedies, that is, whatever the appeals that are available, she should allow all those appeals to happen. That is, if he wants to go up till the Supreme Court, she has to wait till till his case has been finally settled, and even if the apex court says affirms his 7 years imprisonment, only on the basis of that she can ask for divorce, she can file an application for divorce. And the next ground is failure to perform marital obligations for a period of 3 years without reasonable cause. Without reasonable excuse, the wife can get her marriage dissolved by means of a decree. Next ground is impotency of the husband. In case a husband was impotent at the time of marriage, and if this reality or the truth was not known to the wife, and if she's gotten married without the knowledge of this particular difficulty or disability, then subsequent to the marriage, the wife can ask for divorce from the husband. But if the husband becomes impotent subsequent to the marriage, this option is not available to her. Next ground is if the husband is suffering from insanity, leprosy, or venereal disease, becomes a ground for the wife to make an application asking for dissolution of marriage. But then insanity, leprosy, and venereal disease, only if they are of incurable in nature, only then that entitles her to make an application. If it can be cured, that is not a sufficient ground to make an application for the dissolution of marriage. And the next one is in case the parties to the marriage were, in case there was a marriage wherein the parties to the marriage were children, that is below the age of marriageable age, as stipulated by the Child Marriage Resistant Act, that is a boy below the age of 21 years, a girl below the age of 18 years. In case they were married when they were still minors, On the attainment of age of majority 18 years, the right of repudiation of marriage is available to them. That is, on the attainment of age of majority, they can choose either to continue the marriage or to call it quits. But now, in the light of the Child Marriage Restraint Act, this option or this ground may not be available to her. Next ground is cruelty by the husband. What is cruelty? Judicial divorce may also be claimed by a Muslim husband, or sorry, by a Muslim wife, if the husband treats her with cruelty. When I say cruelty, I don't mean to say physical cruelty alone. Here we should also include mental cruelty, like say habitually assaulted by the husband or makes her life miserable by cruelty or bad conduct, even if such conducts do not amount to physical ill treatment. If the husband associates himself with women of ill repute, if he leads an infamous life, if the husband attempts to force her to lead an immoral life, if the husband disposes her property or prevents or stops her from exercising her legal right over it, or if the husband obstructs her in the observation of religious profession or practice, or if he has more wives than one and does not treat all of them equally in accordance with the injunctions of Quran, it amounts to mental cruelty. Based on each and every case, the court will decide whether a particular act of the husband will amount to cruelty. As I already told you, when I say cruelty, I don't mean to say physical cruelty alone. I mean to say that it also includes the mental cruelty. And the ninth ground is grounds of dissolution, that is any other ground, that is whatever has not been mentioned under the above eight grounds, and if a wife thinks that there is something that does not fall under any of the above eight grounds, she can put it on this ground and she can ask for divorce under this particular ground, under the ninth one, that is any other ground. Now, what are the legal consequences of divorce? Legal consequences of divorce are they are not the husband and wife anymore. Children are who are born till the divorce are legitimate, entitled for the property, and the mutual rights of inheritance will cease, followed by dissolution of marriage or divorce. She has to observe iddat, and uh, under Muslim law, the Muslim husband is liable to maintain the wife only when she is observing iddat, but under section 125 CRPC, he is supposed to maintain her till she gets married for the second time. He or she, that is Muslim husband and wife, are free to marry anybody else, but there cannot be remarriage between those two parties. In case they want to get married, then they'll have to undergo this halal marriage or intermediary marriage. Only then there can be a marriage between them. Dower becomes payable, that is, in case a dower, whatever was agreed upon, has not been paid so far, dower becomes payable. These are the legal incidents or the effects or the consequences of divorce. For all further information, please look at the flowchart that is given in the textbook, R.K. Sinha and also Akil Ahmad. If there is any doubt, you can please get back to me. Thank you.